Confidentiality provisions. Non-compete provisions. If you already work for somebody and they ask you to sign a non-compete, they have to give you additional consideration. So if we have a financial advisor, Dan, that's working for you, and you say, you know, those guys, gal, they're awesome. They're doing a great job. I want them to sign non-compete. In Minnesota, you got to give them, once they start employment, additional consideration, additional money in order to make that non-compete valid. All right? You can't just have them sign a non-compete. Now, if it's the beginning of the employment or before they start employment, then you can have them sign a non-compete because employment itself is consideration, but it has to be before they start. Right? There's a lot of times what happens is people go out and sign non-competes and they're not valid because they were signed after the employment began and there was not additional consideration.
On that question on non-competes, if you start a contract and then they want to add in a provision of a non-compete, and they void the original contract, start a new contract, that's the same thing as it started before, right?
No.
It isn't.
No, because you have an existing relationship with them.
Okay, so you have an existing relationship, they cancel that contract,
Yep.
and you start a new one, and this new one has provisions of non-compete.
Yep.
That has to be,
Additional consideration. They argued that continuing employment is good consideration. Hey, you don't sign this, I'm going to terminate you. You can, okay? Said no, continuing employment is not good enough consideration. Okay, you're talking essentially just continuing employment. That's not good enough consideration, right? A promotion can be good consideration if it's combined with an increase in salary and that type of thing. But you got to be really, really careful. If you want the non-compete to be binding, the best thing to do is have the non-competes signed up front. Good question.
What's your, maybe your personal opinion on the validity of non-competes that were signed before employment?
I think the validity,
Constitutionality and things like that.
I think that they're valid. I think the courts will see them as valid as long as they're limited in their scope. And a lot of times what you want to do in a non-compete agreement is you want to put a provision in the agreement that says, look, court, if you think that this is too broad, then you can limit it. But you want to make sure that it's expansive enough to protect you, but not so vast that it just doesn't make sense. For example, Dan, I'm going to pick on you first. Well, I'll pick on Dan Erickson for a second. Is that okay? Okay, Dan, you have a certain geographic area that you do driveways in, right?
Yeah.
Okay, so if your salesperson wanted to take a job in Wisconsin, you'd be, yeah, I don't care. But if your non-compete said, nope, you can't take a job in Wisconsin, because you guys don't do driveways in Wisconsin, right?
Yeah, I have a non-compete with my estimators, it's 50 miles.
Okay, yeah, and see, and I think that's valid, a 50-mile radius is valid. But if you said, you can't do it within the United States, kind of in the United States, the court's gonna come and say, whoa, wait, that's way too broad. You're only doing it within 50 miles of